Social hosts, or persons who permit gatherings on their property for social purposes, generally owe guest invitees a duty of reasonable care to protect the invitees while on the host's property. In addition, in agency law, principals may be held vicariously liable for their agent's torts committed within the scope of the agency relationship. In Yost versus Wabash College, the Indiana Supreme Court considered whether a college could be held vicariously liable for a local fraternity's negligence in causing a student harm. Brian Yost was a college freshman at Wabash College in Indiana and a pledge, that is, a provisional member in the local Gamma chapter of the Phi Kappa Psi Fraternity. As a pledge, Yost lived in Phi Kappa Psi's fraternity house and was subject to the mentorship of a pledge father, or a mentor who was an active member of the fraternity. In September of 2007, Yost sustained injuries in a hazing incident that occurred during fraternity pledging at the fraternity house. Subsequently, Yost brought a negligence action against Wabash, the local fraternity, the national fraternity, and one of the fraternity members in state superior court. In his complaint, Yost asserted three things. First, that Wabash, as a lessor of the premises, had a duty to control the conduct of the local fraternity and its members, and to protect Yost from reasonably foreseeable tortious and criminal conduct. Second, that Wabash and the national fraternity assumed a duty to protect Yost when it took steps to prohibit and prevent hazing. And third, that Wabash and the national fraternity were vicariously liable for the local fraternity's torts. In response, Wabash and the fraternities moved for summary judgment. Specifically, Wabash and the national fraternity argued that they didn't have a duty to protect Yost, and they couldn't be held vicariously liable for the local fraternity's torts. The Superior Court agreed and granted the motions. Yost appealed to the Indiana Supreme Court.